Good afternoon, Mr. Chairman, members of the committee. My name is Kathleen Barrios, and I am a prosecutor in East Baton Rouge Parish. I have been a prosecutor for nearly 12 and a half years, and I hate that Representative Marino has left the room because in 2017 to 2018, I, as well as Representative Marino, several other 88...
He's back.
Several other criminal defense attorneys, public defenders, retired judges, civil practitioners, we served on a legislative task force. And the goal of that task force was to create a clear and regular and transparent sentencing regime for the public. I apologize that I'm having a little hoarseness. And the DAs obviously agreed that a felony class system was the way to do it. But we all agreed on one thing, that it was these back-end sentencing measures that created confusion. And I want to share with you some of the notes that happened during that task force. Mr. Scott Nettles, who worked for Manasseh Gill, a private firm, said the question he hears most from defendants and their families is how much time is a defendant going to serve in jail? And Senator Claytor, who was on the committee said that the only way to even ascertain the answer to that was to call Henry Goins, who's now retired, and ask how much time someone's going to serve. The Secretary of the Department of Corrections even testified that he would be unable to explain to us how to compute sentences because it was just too complicated. And that's what this bill does here. And I want to share with you all some things that occur in court, and I think will hopefully address some of these issues of, adjusting the sentencings. So, for example, some of the plea agreements that I've had to enter into cases involve felon in possession of firearm, a violation of 1495.1. If I want someone to have to serve in prison somewhere between 5 to 8 years, that's a 20-year sentence that the court needs to impose. A conspiracy to commit manslaughter, 20-year sentence, someone may serve somewhere around 5 years, 7 years, 8 years. Most recently in court, we had a defendant who was being sentenced to 1 year suspended, and then being placed on 2 years of probation with special conditions. And he turned to his attorney during the plea and said, so I don't have to do any of that, right? If I just go back in and I'll get calculated. Because he knew I'm only going to have to serve somewhere about 25 to 35% of this year. If we had actual truth in sentencing, we would know what a year meant. We would know what 20 years meant. And if I wanted to accomplish a plea agreement where the person was going to serve approximately 8 years, then we could sentence someone to 8 years. And victims would not be deprived of transparency in sentencing and what it actually means. And Representative James, I want to address something you said about, this person had fallen through the cracks. Even if he had been adjudicated a habitual offender, he would be eligible for parole at a 25% on a non-violent offense. And so he could still be out. And so this bill, and I know that the author is willing to work on what the final numbers are and how it's going to work, but this is something that in a group of people who didn't agree on much, agreed that the back-end sentencing measures deprive the public of what a sentence actually computes to be in the state of Louisiana.
My name is Claire Howington. I'm an assistant district attorney in the 16th, and I handle primarily post-conviction relief and appellate matters. Thank you all for having me here today. The one thing that I really wanted to talk about is just a very tiny part of this bill, but I wanted to talk about what we see as prosecutors when you talk about sentencing and parole eligibility on the back end as the appellate and post-conviction person. What I see a lot of is that people come into court regularly and they say, I took a plea. I thought that I was going to be eligible for release in 3 years, 4 years, 5 years, and it turns out that what I'm getting sentenced under and how my calculations are done, I'm going to be in here for a significantly longer period of time because I fall under a different act. I fall into a different category, and they want the judge to change their sentence. When you have a guilty plea, that is usually not something that's going to happen. However, it has happened more than once and more than 5 times that the defense attorney has come in and said, well, you know what, I actually gave the guy bad advice. I can't calculate these either. I told him the wrong thing. We thought it was going to be this particular percentage, and it turns out not to be that, and you actually end up with an ineffective assistance of counsel problem on a guilty plea, and sometimes those pleas have to be vacated, which means that you have to go back and tell the victim of these crimes that not only was what you expected going to happen in the first place, not actually what happened, but now we're going to have to start over again and either offer this person a different plea or possibly take them to trial. And that's just re-victimizing them again. So I think that having everyone in the courtroom know what happens when you take a guilty plea is a benefit for not only the victims and the DA and the defense attorney and the court and the public as a whole, but also for the defendant.
I guess the plea piece, victims aren't you guys supposed to go over the sentences with the victims? Right.
I think, Representative James, how can you do that when there is a system that is so complicated that even the Secretary of the Department of Corrections can't explain it, and the computations are resulting in what we've heard here in this committee today, people being held in jail longer than they're supposed to? No one here wants people being held in jail longer than they're legally supposed to be. So what if we prospectively fix this, that won't happen.
But so my question is, although the system is there are a lot of things about the system that I think we should fix, right? If 105 people agree with me, we'd be a lot more further, in my opinion, and I'm sure Fontenot probably feels the same way. But under the law today, it's so convoluted. What do you guys, when victims' rights, are they required to be told about the sentence? So what are you telling them today?
Well, as the post-conviction person, I don't make a whole lot of plea offers, but what I tell people is that this is the plea offer that's been made. I do not feel like I am qualified to tell you exactly how much time this person is going to spend in jail. When I make the offer right now, my expectation is that they're not going to spend that entire time in there, but calculation is up to DOC. So we'll just have to see.
Okay. And on that, with this guy, why? I mean, couldn't you guys have, couldn't it have been like a multi-bill for maybe negligent homicide on the family that came? Like what, because a lot of times, even with the fact that you guys are going forward with pleas, that tells me that you initially filed some charges that either you probably having a hard time proving those charges, so you issue a plea. And those are conversations that you got to have with families as well, and maybe stop charging certain things if you don't have the facts to prove them, because I mean it's a lot of different factors, and it's not just the fact that the system is so hard and victims. I mean, what are you guys telling the victims now?
Well, Representative James, I would say though that, as I just pointed out, on a negligent homicide, that person, even as a habitual offender, would be eligible for parole.
Exactly, and what are you telling the families? Because it seems as if you can't just tell them, look, I don't know what's going to happen. That can't be. I know that's not what you do, Ms. Barrios, because I know you very well. So I mean, you guys have and I'm not putting it all on you guys. I know your jobs are hard. I haven't had to be in your shoes, so I can't, fully speak to it, but I'm pretty sure that you guys are telling them something. I know you're not just telling victims, look, the system is so bad, we live in a state where I don't know when they're getting out of jail. I know you're not saying that. So what are you saying?
That we can't provide them any assurances on what the sentence is, because it is something calculated by the Department of Corrections. And I think what Ms. Howington is pointing out is that it puts defense attorneys in a very difficult position where they may be ineffective, could face discipline with the bar if they are making certain guarantees to their clients.
Okay. Oh, yes, you do. Representative Marino.
I was trying to eat lunch so that I wouldn't go right back to the floor again without. So how we got here is this book is so big because in Louisiana, we make a law and a sentence and a law and a sentence and a law and a sentence instead of the felony class system, that task force that was the recommendation of Justice Reinvestment. That's the way you go about transparency and sentencing, is you don't put every separate crime with its own sentencing rules and then amend them 25,000 times, which is why they can't calculate it. You put all the crimes into a box, and these are the set and clearly defined rules for every one of these. So when you make a new crime, you don't make a new crime, make a new sentence. You put it into the box. And it's very, very, very clear that and I even asked the question, if we had a felony class system and we made it retroactive, They could tell you today, right now, how much time everybody would serve. But no one wants to make it retroactive because we made all these promises and all these rules and all these promises to victims, and it might be slightly different. So and this bill doesn't address all the 29,000 people in jail right now. It's just going forward. The way to do it, according to the task force, is a felony class system that we started on, and it failed because we couldn't get agreement on coming up with ranges of times for things like armed robbery. This bill eliminates parole. What it's good at is putting people in jail and saying how long you will be in jail. It's not really designed to be rehabilitation. It's incarceration, so that you can know exactly how much time you're going to be incarcerated. You do know that we in this bill, you still have ability to get reductions in time. So you're not going to know exactly how much time they're going to serve, because they still can get reductions in time, which you call the back end stuff, which is the rehabilitation stuff.
It's not just the back end stuff, though. That's rehabilitation. It's the good time calculations that apply to people, regardless of that changes if you're a first offender, changes if you're a first time violent offender, a second time violent offender. And Representative Marino, at that task force, when Mr. Vining testified, they said that the felony class system would not repair those problems. That simply
the past, the ones that we already sentenced, because we're not going retroactive.
Right.
You
so
can clearly set all the rules for everything in the box. Are you parole eligible? Yes or no. Are you good time eligible? Yes or no. Can it be expunged? Yes or no. It's very, very. Other states do it. We can do it. This book would go down to about this big if we did if we did that. This is not the way to do it in the name of transparency. Not even close. That's my opinion. It's not really a question. I have to say, did you know?
You could give opinions in here.
That's my opinion.
Yeah.
And I have spent the time working on this. Way more time than my seatmate has. I promise you that.
She may disagree.
No, it's okay.
I don't think she's listening to you right now.
She don't listen to me.
Oh, she's typing notes.